Thank you, Mr. Chairman. Mr. Chairman, I'd like to submit to the record a letter from the American Legislative Exchange Council.
Without objection.
Judge Barrett, I want to talk about religious freedom for a moment. As I mentioned the other day, I think you and I share something in common on this, an enthusiasm for religious freedom. As I mentioned the other day, I'm a member of the Church of Jesus Christ of Latter-day Saints. We have been no strangers to religious persecution, even in this country, unfortunately. On October 27, 1838, the governor of Missouri ordered us exterminated. It wasn't nice, but, you know, I assume he had his reasons. He believed we were heretics, and I'm sure we are heretics in the eyes of many, but we try to be really nice heretics. And it wasn't until the late 70s that the governor of Missouri actually lifted that ban. I'm sure Josh Hawley, as Attorney General, would have lifted it for us had it not been lifted by then. Religious liberty has always been interesting to me for that reason, and also just as a lawyer. My late father, who was also a lawyer, worked on and advised Congress regarding the Religious Freedom Restoration Act. And my longtime professional mentor and former boss, Gene Scher, was someone who I worked with in establishing a first-of-its-kind religious institutions practice group a couple of decades ago. Catholics, like members of my faith, have also been subjected to religious persecution from time to time. And in many cases were directly targeted through so-called Blaine amendments, provisions worked into a number of state constitutions, really for, in many cases, blatantly anti-Catholic purposes. These Blaine amendments had, of course, as their purpose the restricting of public funds going to certain religious institutions, including schools. Thankfully, earlier this year, the Supreme Court in Espinoza versus Montana Department of Revenue struck another blow against Blaine amendments by reinforcing their earlier decision in the Trinity Lutheran case. Would you discuss briefly with us the Supreme Court's recent jurisprudence on this issue regarding Blaine amendments and how they intersect with religious freedom?
Sure. So the Supreme Court's recent decisions get at the principle that while, you know, we have to be careful about the Establishment Clause, right? So there's a line of cases saying, you know, a state or federal government clearly can't establish a church, and so we have a line of cases about what that means. But at the same time, Espinoza being an example, the court has been very clear that religious institutions can't be discriminated against or excluded from public programs simply because they are religious.
Now, during your time on the Seventh Circuit, you've been able to handle some cases involving religious freedom issues. For example, you joined a majority opinion in the Gruscott case, upholding the freedom of a Jewish religious school and its authority, its own discretion to hire teachers at its school. Now, that ruling was challenged before the U.S. Supreme Court, but the Supreme Court denied certiorari in that case. But nonetheless, a 7-2 majority of the Supreme Court in the Our Lady of Guadalupe case ended up essentially adopting a position similar to that which you joined in the case I just mentioned, in the Our Lady of Guadalupe case. Can you talk to us just a little bit about that opinion and about the Seventh Circuit opinion and its application of the ministerial exemption?
Sure. So the ministerial exemption, as you say, you know, the court had described it in Hosanna Tabor. The ministerial exception gives religious institutions discretion to hire, and in the case of a school, teachers. It's called who are ministers. And what this gets at, or what this requires courts to do, is to decide who is a minister. And on the one hand, there may be some which you could plainly, you know, what might be more obvious questions, like, you know, someone who teaches religion teachers. So what the court has said is, you know, those would follow more in the heartland. It gets a little bit more difficult if you have a religious school like the Jewish school in Gruscott or the Catholic school in Our Lady of Guadalupe, who has a teacher that's like, say, for example, teaching math. And then the courts have to come up with a test to decide whether such a person is a minister or not. And what Gruscott and Our Lady of Guadalupe said is it's a multi-factor test where no one factor is determinative. So it can't be determinative just that the teacher teaches math rather than religion. For example, in Gruscott, the teacher spent time teaching Jewish prayers and saying Jewish prayers with the class. And the school considered it part of the teacher's duty to form the students, to teach them about Jewish prayers and to form them in that tradition. So even though she spent other time in the curriculum teaching other matters, it viewed that as part of her job, and the school viewed her as a minister. And so Our Lady of Guadalupe gives a lot of deference to the school's characterization of whether someone is a minister or not to encourage discrimination, of course, but simply to protect religious freedom. So at a Catholic school, the teacher may teach math, but also prays with the students in the morning, attends Mass with them during the week, and is considered by the school, say in Our Lady of Guadalupe, to be someone who is also forming children in the faith. So it's really about what the scope of that ministerial exception is and how you identify whether someone is a minister.
Thank you. Thank you. That's helpful. When you came in front of this committee in 2017, we're talking about just over 3 years ago, for your confirmation to the U.S. Court of Appeals for the Seventh Circuit, you said, quote, "If there is ever a conflict between a judge's personal conviction and that judge's duty under the rule of law, it is never permissible for that judge to follow their personal convictions in the decision of the case rather than what the law requires." You still stand by that statement?
I do.
I've got some colleagues on the other side of the aisle who seem to want to focus on statements made in your personal capacity and in your capacity as a private citizen and a member of your faith, as opposed to addressing actual cases dealing with abortion. I have a hunch that this is because your record on the Seventh Circuit actually shows that you're able to set aside your personal convictions, because that's what you've done when they've conflicted with your duty under the rule of law. In Price versus Chicago, for example, I assume you remember that case. It's a case in which you joined a Seventh Circuit panel opinion affirming the legality of a Chicago buffer zone law, which places limits on pro-life activists as they're demonstrating, exercising their First Amendment rights outside of abortion clinics. I assume that was the case because there was binding Supreme Court precedent on the abortion buffer zone issue. Is that right, or do you want to tell me a little bit about your reasoning in that case?
So the panel held that the issue was squarely controlled by the Supreme Court's decision in Hill versus Colorado.
So there was binding precedent on point, and so you followed that precedent, and you did so as a jurist, rather than following whatever personal predilection might have otherwise guided you or any other member of that panel. In Planned Parenthood of Indiana and Kentucky versus Commissioner of Indiana State Department of Health, you joined a dissent written by Judge Frank Easterbrook of the Seventh Circuit. And the Supreme Court later agreed with you in a 7-2 decision with respect to the Indiana law requiring fetal remains to be buried or cremated following an abortion. A position that garners a 7-vote majority on the Supreme Court these days, at least a 7-2 decision that includes Justice Breyer and Justice Kagan. Does not seem very radical to me. Do you disagree? Am I missing something about that?
The Supreme Court summarily reversed, which means without argument and briefing, the panel's holding in that case that the fetal remains, the disposition of fetal remains portion of that statute wasn't rational.
And I'll note for the record here, I don't think I've ever heard anyone characterize as a radical act of conservative activism a 7-2 decision joined by Justice Kagan and Justice Breyer. Judge Barrett, in addition to being able to set aside your personal convictions when deciding a case, you've also demonstrated the ability to expertly determine what the law requires. This stems, I believe, from a fundamental and, I believe, correct view that a judge needs to start from the premise that the law provides an answer. The fact that legal disputes can be difficult and reasonable minds might disagree as to them doesn't excuse the judge in believing that there is a right answer. And you seem to follow with that, and it shows up in your work in a way that reflects very well on you. The Congressional Research Service conducted a review of your cases from the U.S. Court of Appeals for the Seventh Circuit and determined that your decisions, and this is a quote, evince case-by-case consideration of the relevant law and facts without any clear overarching trend toward either expanding or narrowing Fourth Amendment protections, close quote. Now, this is exactly what I would expect from a textualist originalist on an issue that, like the Fourth Amendment, can actually be politically charged. But with the textualist originalist, this is exactly what you'd expect to see, somebody who doesn't appear to be a partisan one way or another and comes down on both sides, on the government side and on the non-government side. This would also account for a variety of outcomes in your cases because you're not aiming for an overarching trend in outcomes. Your analysis seems sometimes to come out in favor of a defendant, sometimes in favor of the government. I find your dissents and your concurring opinions in panel decisions that demonstrate this commitment to following the law as it's written, rather than on the basis of some external objective. Can you tell us why you felt the need to dissent in the case of Schmidt versus Foster?
Yes. So Schmidt versus Foster involved a state court case. It came up through the Wisconsin courts. And in the case, there was a question of whether the defendant could raise a defense under Wisconsin law called adequate provocation for having murdered his wife. The case wound its way through the Wisconsin courts, and the defendant argued that an ex parte examination of the judge at which his counsel was present but not permitted to speak did not violate the Sixth Amendment, because in that case, the defendant didn't want to preview his case for the prosecutor, and so he didn't want the prosecutor in the room. So the judge said, well, I will allow that, but only if your attorney doesn't speak, because, if we're not going to preview your case for the prosecution and not permit the prosecutor to be here, that was how he's going to do it. So then the judge proceeded to ask the defendant questions to decide whether he could make an adequate provocation defense, and concluded that he could not. In that case, the Wisconsin courts held that this proceeding did not violate the defendant's right to counsel, telling his counsel that he couldn't speak. It came to my court under 2254, which is the state habeas statute permitting collateral review of state convictions. But EDPA requires very heavy deference to state courts. You can only disturb a state court holding, for example, on a matter of law, determination on a matter of law, if no reasonable jurist could reach that conclusion, or it has to be in conflict with clearly established Supreme Court law. And in that case, I made clear that it wasn't up to us to decide whether we thought as an original matter, just if the case had just come up before us, whether that violated the Sixth Amendment, because as the panel majority, which then became a dissent when the case went en banc, said this was an unprecedented kind of hearing, which If it was unprecedented, meant that there was no clearly established Supreme Court law on point. So the decision in that case was driven by federalism and by the statutory instruction that federal courts give deference to state courts.
Thank you. In another case, United States versus Wilson, I believe that was a case in which you agreed with the majority in concluding that the officers acted with reasonable suspicion based on the circumstances of the case and the detention there involving a flight by the individual from the scene. But you wrote separately. Tell us why you wrote separately in that case.
So that case, if I have the case correctly, so I've been almost 600 cases, but I think I know the case that you're talking about. I think that was a case where police had a tip about some criminal activity, and there were a group of men in a park. The police approached the park, and then they went up to talk to one of the men at the park because they noticed a bulge in his pocket. He was wearing gym shorts or some sort of athletic shorts that showed a bulge. And the police approached the man, and he fled. And under Supreme Court case law, the determinative question for a seizure is, whether the person fled and then was detained, then seized by the police. The other way that could have been justified is if, as a matter of a Terry stop is the case, the police had reasonable suspicion to approach him just because they saw the bulge in his pocket. And I wrote separately because I thought that the policeman's basis for stopping him, if this really had just been a Terry stop based on reasonable suspicion, was questionable because they really had, they had an anonymous tip. The people in the park didn't match the description of the description given in the anonymous tip. All they saw was a bulge in the pocket. So if he had not fled, I thought the case should have just talked about the flight, because if he had not fled, I was pretty dubious that would have been a justified stop.
I admire your decision to write separately in that case. I think that shows real courage and moral and judicial leadership to speak out and write separately when the occasion requires it. And you did so here with nothing to gain from it. You did so because it was important to point that out under the law, and I respect that a lot. In the couple minutes we've got left, I wanted to ask you more broadly about something I've noticed in reviewing letters and other materials we've received in response to your nomination. I've noticed that there's a common theme among your law clerks and your students. They feel like you see them as individuals, and they feel mentored and taught by you. Tell us a little bit about that. I'd love to hear, for example, how you go about deciding who to hire as your law clerks, and how you mentor them as they go through their year studying with you.
So over my teaching career, I've taught roughly 2,000 students. And now I have, as a judge, 4 law clerks per year. And then I also continue to teach at least a seminar in which I have like 15 or so students usually. And what I'm looking for in a law clerk, of course, is excellent legal ability, because I need the help to do the legal research and all of that sort of thing. So I want someone who has excellent legal ability. I want someone who has integrity. I want someone who isn't afraid to push back and express his or her own opinions, but at the same time realizes that, I am the boss, and if I disagree, then they're going to have to go along ultimately. But I also want clerks who are, and this is part of the integrity, who have character. Our chambers is small. If someone had, say, sharp elbows, in a chambers that only has 6 people, my assistant, the 4 law clerks, and me, or that showed disrespect or arrogance, that would make for a pretty miserable year for everyone. And I've not been disappointed. Every one of my law clerks has fit that bill. And so I view it as my duty with my law clerks, much like with my students, to encourage them to enter the profession as full people who hopefully have gained some knowledge of the law in their time with me, and also seeing how they can, live a life where people can disagree without being disagreeable.
Thank you, Judge Barrett. I see my time's expired. Thank you, Mr. Chairman.